Any mention?
Yes.
Please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item 17, my lords. Item
17?
Yes, my lords. 1 second.
After how long?
Lordship, there is some difficulty on the part of the senior counsel today, my lord. Lordship may kindly post it.
After 3 weeks.
Any other day as per my lord's convenience.
3 weeks, yes. Right, 3 weeks. Yes.
May I pay for a fixed date, my lord, here?
That the good master has to give you because we're a bit, you collect it later. Tell your local council to collect it. Yes.
Obliged. Hello.
Lordship, item number 13, Lordship.
Number?
13. I'm praying for 2 weeks' time, Lordship. I've already taken the concern, Lordship.
Where's the other side?
I've already taken the concern, Lordship.
So we'll take your word for that, okay. 2 weeks, yes.
Obliged, Lordship.
May it please your Lordship. Lordship, I beg to mention item number 15. I've taken the consent from the other side. This matter may kindly be taken up after 2 weeks, madam.
I'm for respondent 1 and 2, Your Lordship.
Okay.
Much please.
May I please your Lordship, I beg to mention item number 11. I'm praying for this letter to come matter after 2 weeks.
2 weeks, yes.
Similar prayer for item number 14, your Lordship.
13?
14.
Where's the Changrai? So he's not come today.
Sir, is there some part matter is there?
Okay, yes.
May I please your Lordship, I beg to mention item number 16.
No urgency?
I prayed urgency is there, your Lordship, as the conducting counsel is on leave, your Lordship. So if this matter can come after a week, your Lordship.
Let him get well, he's sick.
Yes, your Lordship.
Call it after 2 weeks, yes.
After a week, your Lordship.
2 weeks, 2 weeks. Let him get better then. Let him get fully fit. Okay. Yes.
Obliged.
Yes.
Supplementary list, item number 1.
May I please, Your Lordship? Your Lordship, this is the matter pertaining to the non-disposal of my representation given to JHDC.
What representation?
Actually, I'm the owner of a plot of land in Bedalpara, Tura, where I have constructed a building after obtaining due permission from Muda only in the year 2007. After that, after I finished my construction, my neighbors on both left and right side of my land, they started constructing. And I didn't have any issue with that. But later on doing so, they started to encroach upon my land. So I made a formal complaint to the Muda, authorities of Muda. Then nothing was done. I was just waiting for the response. Then on.
When did they start encroaching to your land?
After 2007, when I finished my construction.
So then you didn't file a suit or something?
No, I just approached them. I requested them not to do so because I didn't have any issue when they were constructing. But when they started to encroach upon my land, I just requested, because they happened to my relatives also, both outside. But they did not pay any heed to my request, and I made a complaint in that year only, but I don't have any record of that. But nothing was done from the...
Since which year you started constructing?
After 2007, I don't know, maybe after I finished my construction. So after that, I made a complaint later on, and I wrote a letter to the Secretary Muda on 25 May 2022. Then after that, again I was advised by the concerned authority to address the letter to the town planning officer. Then after that, I again wrote a letter to town planning officer in the year 2023, 9th January. If you can kindly go to Annexure 6, my lord, page number 27. I have made a complaint. Then along with that, I also attached a few photographs just to prove that.
Annexure 7?
Annexure 6.
6, yes.
6 is the letter. Then after that, Annexure 7 are the photographs which I...
What photo? You mean these buildings only come up?
Yes,
This
they
is
have,
after your building.
they started to encroach upon my setback areas.
It's too late.
But I was waiting for the response from the.
Demarcation now, even this is in your property, what will happen? You'll have to ask for demolition, then you have to get a order.
That's what I'm coming to that point, Your Lordship. Then again, after the complaint letter was done, the town planning officer issued a show cause notice to both my neighbors, that is Mr. Gun Bahadur Chetri and Srimati Tilmaya Chetri. And after that, order was passed by the town planning officer Muda. And as per that is page number 49, annexation 9, Your Lordship. Order was passed by Muda, town planning officer, and in that the town planning officer had directed us to demarcate our land and submit
But
the report.
demarcate after the construction has been done.
I was waiting for all these years for any action from the Muda side. Then, Your Lordship, after that, I wrote a letter to the concerned authority of GHDC, settlement officer, to kindly do the needful for demarcation. And after that, that is annexure number 10, page number 51, Your Lordship. Then after that, I was directed to pay challan of ₹2,000 for the demarcation. That is page number 54, Your Lordship.
This is Patalan of Garo Hills.
Yes, Your Lordship.
Why is not demarcated before? You'll have to file a civil suit. Yes, anyway.
Yes. Then,
At this stage, you will give you notice.
Your Lordship.
Because the
No, I just pray, Your Lordship, that the Your Lordship may direct the concerned GHD to do needful, because they have already taken
instructions first.
my fee.
Yes, heard
2,000
US
rupees.
Thapa.
Yes, Your Lordship.
Service Panel Council Petitioner issued notice. MS N. Raji is present on behalf of the respondent number 1. Accept notice. Why you made it two respondents? Where are the private respondents?
The respondent, I think it's Mr. P. Nongbri.
No, wait, where private respondents did not meet those people?
No,
you have
no.
issue then?
Actually, I just wanted to direction. I wanted a direction to be given to the GHD, because since they have taken taken the fee, they have not done anything. I gave them reminder letter also, but nothing else till now.
Okay, who's appearing on behalf of the Buddha?
I think Mr. P. Nongbri. During the course of the day, I'll serve with the copies.
You ask him, is he there? Is he standing counsel?
Actually, I don't. Oh, sorry.
Are you standing counsel Buddha?
Yes. You can serve.
You been served?
I'll during the course of the day.
He served. Yes.
Yes.
And Raji acceptors, we have no one. Mr. P. Nongbi on behalf of responding but 2. So bless this matter after 10 days for. You get instructions from number 1.
Yes, Your
Yes,
Lordship.
if there's any representation pending. Yes.
Obliged.
Item number 2.
Yes.
May it please Your Lordship. Your Lordship, in this matter, Your Lordship, the petitioner was formerly working in the Kendriya, Vidyalaya, Sangathan, Happy Valley, Your Lordship. Your Lordship,
Formally working, you're saying?
on contractual basis, I was a teacher there.
Now she's out of service.
Yes, Your Lordship.
Okay.
Your Lordship, now on 29/8/2023, Your Lordship, I had verbally made a complaint before the principal for sexual harassment at workplace against one of the teachers, Your Lordship. And then on the 6th, Your Lordship, I had made a formal complaint. Now, Your Lordship, on the basis of the complaint, a committee was formed, an internal complaint committee was formed, an inquiry was conducted. Thereafter, another inquiry was conducted by the IC at regional level. At
Does it
first,
have a meaning?
Your
School
Lordship,
level, they don't have internal complaints
they
committee,
had, Your
right?
Lordship. That was concluded. I was not informed whether it was concluded or not also. Thereafter, they started with another inquiry at regional level.
Regional level meaning?
Regional level, Your Lordship,
But they're regional officers of Kendriya Vidyalaya because they have schools all over country.
Yes. Then?
Your Lordship, I am here, Your Lordship, because I'm aggrieved not only with the manner of how they conducted the inquiry, but also, Your Lordship, the constitution of the
Internal
ICC
complaints
members, and also the findings of the inquiry report, Your Lordship.
You take notice. Yes,
Only thing about the alleged perpetrator is not made a party. Really necessary party.
If it's necessary, we'll plead in your lordship.
We take notice of this. Heard MS CV Soil and Counter Petitioner issue notice. There was the DSJ accept votes on behalf of
All the respondents.
all the respondents. Just after 3 weeks for instruction affidavits, the petitioner was given liberty to plead other necessary parties if deemed as if so advised. Yes.
Obliged.
Daily list item number 1.
Yes.
May it please your lordship. Lordship, this is a review petition against judgment and order dated 24/11/2023. This was a common judgment passed in several...
Where are all other co-participants of this matter?
My lord, on behalf of Mr. S, she's there.
You ready with the matter? You ready with the matter?
My senior is coming,
Where is he?
He's coming.
Okay. Yes.
This particular judgment was passed in a batch of 7 writ petitions, lordship.
7 writ petitions?
7 writ petitions. It was clubbed together. The issues were interconnected, though not exactly the same. In some cases, there was a claim of salary. In some cases, there was a dispute as regards who is the head teacher. In one of the cases, the petitioner herein had challenged the appointment of Shobuza Begum, who was the respondent number 4 in that particular writ petition.
Okay.
Now, lordship, one of the writ petitions, that is WPC 119 of 2022, I have not been able to file a review petition in this particular case now because this WPC 119 was filed by the managing committee of the school. And at present, I am not holding any position in the managing committee of the school. So I could not file the review petition. But the review petition filed in other 3 cases, that is WPC 383 of 2017, WPC 264 of 2020, and the last one, that is WPC 147 of 2022.
You filed 3 review applications.
3 review applications.
What about this other 456, 460, 460?
Other writ petitions, lordship, some had become infructuous and some are not related. I am not agreed with any order passed in those writ petitions. My basic grievances are in these 3 writ petitions. If I may take your lordship to the...
What do you agree? What's wrong with the order?
Yes, lordship. I'll specifically pinpoint only those portions where it appears that there is an error apparent on the face of the record. Only that much, lordship.
Very limited. You can't bring anything new.
I am not bringing anything new, lordship. I will be relying only on the records which were before this honourable court in the writ petition.
Yes.
There are...
Then only before the court at that time, then there's no question of review.
Yes, lordship. It is at that point of time. And I will pinpoint, lordship, how there is an error. If I may take your lordship to page number 23 of the petition.
Yes.
Lordship, the 6th line from the top, paragraph 3.
Yes.
If your lordship find it, a case in point is WPC 383 of 2017. A case in point is WPC 383 of 2017, wherein the petitioner, who is a sanctioned teacher, namely Srimati Nazila Begum, has not been paid her salary from the month of January 2021 till date. Now, lordship, if I may take your lordship...
No, what do you want to show from here?
Yes, lordship. The error that is
What
here...
error?
Yes, lordship. That is what I am pointing out.
Something can be overlooked by the court, but does it have any impact on the
It
outcome?
is having an impact on my service, lordship.
You are an illegal teacher.
No, lordship.
Yes.
Lordship, the inquiry
That's the
report...
finding of the inquiry.
Lordship, the inquiry report itself has enclosed that I was appointed in 2010 and I was approved.
The review...
In the inquiry report itself, it's there, lordship. The annexure 2 of inquiry report, that is page 24. If your lordship has the inquiry report.
It is not part of the review application, your lordship.
Lordship, it's a part of the writ petition, the entire record. The entire record, the inquiry report was taken on board in the writ petition.
In fact, Your Lordship, the review is on rehearing in the sky, Your Lordship. If
Hearing in the sky.
Lordship.
We didn't go for appeal.
If Lordship, I'm coming to that. If Lordship kindly come
I
to...
am clarifying on what ground I have withdrawn the
If
appeal.
there's error committed by a single bench, very well, file an appeal,
Lordship,
get it set aside,
but
and get the
Lordship,
matter
Lordship,
fresh.
this
kindly come
particular
to, page 37, Your Lordship.
Yes.
Lordship, kindly come to page 37. What is the grievance before the appellate court, Your Lordship?
See, otherwise review, sorry.
Lordship, kindly come to page 37.
Yes.
Paragraph 4 of the order passed by the division bench. At this point, it is brought to the notice of this court by the learned counsel for the appellant that since the report has got a bearing on the issue involved in the case, despite her verbal request for furnishing a copy of the report, the same must not be provided. This is the only ground, Your Lordship.
This was not the only ground, Lordship, but since on this particular ground,
You see, it is not a disciplinary
It is not a
inquiry
departmental
or
proceeding, Your Lordship.
proceeding where entirely
that
brought.
is
This
why-
was at the instance and under orders of the court, because of all these illegalities happening in all these schools or whatever, the 7-8 cases
Lordship,
from the
I
same
may-
school, right?
Lordship,
That
yes,
is why.
correct, absolutely
That is the
correct.
court
Lordship
deemed
is
it like
absolutely
it was
correct on
difficult
that
to
part.
discern. That's why we asked for inquiry. Inquiry was furnished,
Lordship,
and we were heard, and that's it.
that's what, Lordship. After the pronouncement of the judgment, we got a copy of the inquiry report. That too, we applied for an uncertified copy of the same. And now, upon going through in detail the inquiry report, there are points in the inquiry report also which prove that there is an error apparent on the face of the record. The state government had filed its affidavit in
And file
WPC.
an appeal again.
Lordship may kindly hear.
See, the thing,
Lordship,
review,
if
see,
the-
one thing is we have, the court's taken us whatever's to the best of our knowledge
Lordship may-
and appreciation of the materials on record and submissions.
Lordship-
We pass the order.
Lordship,
so unless
the
you can show
materials-
something glaring that has escaped notice of the court,
Yes,
number
Lordship,
one, or
if-
some new events, new things, you open. See, what is the
Lordship,
review is limited to what?
It is limited, my lord, to error apparent on the face of the record. So I am going to show only that, Lordship. I am not going to go beyond that.
How will it
I
impact
will not
your
go
case?
beyond that. It has an impact on my case to the extent that the inquiry report says that I was not a legally appointed teacher of the school.
Right.
And on that basis, this instant judgment has been passed.
Yes.
Whereas, Lordship, this inquiry report has also been prepared by the state government as per the direction of this honorable court. And in another case,
After hearing everybody,
Lordship,
see,
the inquiry report,
Opportunity is given to everyone. Do you mean to say that your petitioner was not given adequate opportunity to present himself, to present his case before the
Lordship,
the officer cannot inquire?
the inquiry report, if your Lordship has already perused, your Lordship has already perused, in the inquiry report, it is written that every single person was heard in person.
Yes.
But this inquiry report, it has not enclosed the statement of any of the persons who were heard in person. Secondly,
that we can't go into that.
Second, I'm not going on that, Lordship. I will not argue that also because
Were you
I am-
heard or not for inquiry? Yes
Lordship,
or no?
but nothing
Were you
is
heard or
there.
not?
But Lordship, that is not before your Lordships.
Were you heard or not?
But that is not
No,
before
were
your
you heard or not?
Lordships.
Yes or no?
Lordship, I had submitted written argument also. I had submitted the documents also. But nothing has been produced before this honorable court. That is why I am trying to show it
You
from the
file an
records
appeal.
itself.
Okay, you've got an inquiry and file appeal. Not
From the records itself, I am showing Lordship.
Yes,
From the Lordship will kindly see the record once, Lordship, just
it's a
once.
review application. You file an appeal.
Lordship will kindly
File an
see.
appeal, see the review rejected. So you file an appeal.
Lordship will kindly see.
Then, see, writ appeal, your whole, the whole, what do you call your game can open again, right?
Lordship
Review-
will kindly see the error
unless
apparent on the face of the record.
We will not go there. The
Lordship,
court has
the state-
examined the inquiry report as it has been presented. You all were heard in the inquiry, and orders were passed thereon finished.
Lordship, but the affidavit which was filed before this honorable court by the state government, that was on oath. It has got bearing. And
See,
the
shows-
inquiry report is contradictory to the affidavit filed before this honorable court, and both the documents have been filed before this
More the
honorable
reason
court
you
by
filed
the
appeal.
state.
Yes. What do you have to say, Mr. Shulain?
Lordship, my humble and respectful submission, Your Lordship.
Unless it shows something that is really glaring,
Yes,
you know,
Lordship, it is, Lordship. If
that
I
has
may be
caused grave
permitted to
miscarriage
show.
of justice.
Lordship, if I may be permitted to show, then only I will be able to. I have pinpointed.
That's the only thing you pinpointed.
No, Lordship.
Finish.
Lordship, I may be permitted. I have pointed out specifically
Okay,
the
what
portions.
What are the points you're saying that,
Lordship,
that needs
pa-
review?
Page 23, as I have just shown that Nazila Begum, she has not been paid her salary from the month of January 2021. Lordship, the state government had already terminated her from service way back in the year 2017.
Okay.
Lordship, so the question of paying salary from January 2021 does not arise.
Okay.
Second point, Lordship.
Is that a recording of submission? See, that page 23.
Yes, Lordship.
Let's see. This is she is the petitioner in that case, right?
She is the petitioner
Yes.
in 383.
Fine. What is the finding on this?
The finding on this,
That
Lordship,
she has not paid, that she's the teacher now also.
Your Lordship has directed that Nazila Begum should be paid her salary.
Where was she terminated in 2017?
Lordship, that has been annexed in the affidavit in opposition
No, have
filed
you
in
put it here
WPC
in your
383.
review application? No.
Yes, Lordship, I have mentioned.
Where? In your petition? No.
In the grounds I have mentioned.
No, the annexure, is it there?
Lordship, that particular annexure I have not annexed, but I have stated because that was already a part of the writ petition.
Then you file an appeal then.
It
Where
is
is
a
that?
part of the writ petition.
Then you file an appeal. Why you do the appeal? You would do the appeal.
Lordship, yes, the only ground before the appellate bench is that, Your Lordship, a copy of the inquiry report has not been furnished in spite of the verbal request.
Lordship, that was my first ground, and on that particular ground, since the court had said that the inquiry report has not been served to you, you file a review. And I did not argue on any other points which were raised in the
We don't
appeal.
know what you argued there.
Our contention before the appellate bench is that, Your Lordship, this is a court ordered inquiry. So the writ applicant and Lordship is not entitled to such a report.
No, he's not entitled to the report. But
Lordship, yes, that is our case before the honorable division bench, Your Lordship.
Now, Lordship, that is why this.
Yes. See,
If
the
I may
directions
show the.
pass in the order.
If
Now the thing is that you have been found to be you disruptive element. You have been found to fabricate documents. You don't dispute that.
we do, Lordship, but that has been
See.
That has
Please
been
don't-
clarified,
please don't
Lordship.
Stress only on the one point that you found.
Not
Now,
one
what
point,
about your
Lordship.
conduct?
About the conduct.
Are criminal proceedings pending against you now?
Lordship,
Yes,
Have you
Lordship.
started now? Then
Lordship, yes.
Lordship, regarding
You file
that
appeal,
particular
yes.
point,
yes, Honourable Counsel for the petitioner. No grounds are made up for review. The appeal stands dismissed. You can go and file appeal. We'll not go and enter into the entire inquiry report again.
Apply, Your Lordship.
Item
One,
two.
1, 2, 3,
As
Your
far as
Lordship,
there's
same
something-
order.
If there's something which is glaring, yes.
Lordship, 1, 2,
there are. I have
1, 2, 3, Your Lordship. Apply,
1,
Your
2, and 3 are connected, Lordship.
Item number 4.
Very good. Yes.
Lordship,
Yes.
I'm praying for some accommodation in this matter, Lordship.
How much delay?
238 days.
Any objection?
We are not filing any objection, Lordship.
They have already filed it.
Okay, then just a matter after 1 week due to as the High Counsel for the petitioner is not present.
Much obliged, Lordship.
Item number 5.
Your Lordship, we have filed our affidavit in reply to their appeal. Lordship,
Yes.
we were given what had happened, we were given a plot of land. Now they want us to sublease it to them. We said the terms of the lease do not permit. Simple matters, if you cannot, don't give us.
Yes.
Let us do something on our own.
Right.
And the other one, you take a call. That is for them. That's the only thing. There's no point saying that we should do this and we should do that.
Yes, Mr. Khan. We'll close the petitions. Versus this, this is the way you got a plot of land, 224.
Yes, we got a plot of land. So we do what if we don't are not agreeable, we'll set up our own, go for some other OMs, right?
Absolutely. No quarrel.
No quarrel. He also has no quarrel to that.
Absolutely. You're perfectly fine. You want some other relationship, go ahead. We can't force you like that.
Neither can we go now.
And the second one?
Second one, Lordship, they had decided behind the back, let them give us a hearing and dispose it off.
Lordship, we had recalled the order. The only thing,
recalled the order?
There was an order that not to give effect. The only grievances, Lordship, was that they were not heard.
So let's just let them give us a hearing and decide.
We'll pass orders on the first one first. Yes, take down. The petitioner before this court is a dealer of Indian Oil Corporation Limited and is stated to have been in business since 1930. The retail outlet from its location was shifted, right?
Evicted, Lordship,
Yeah.
vacated. They were asked to vacate.
Yeah, problem. But the retail outlet which was situated on defense land had to be discontinued in as much as the defense estates officer had communicated to the petitioner that leasing of defense land to public oil companies for retail outlets, for petrol pumps, etc., were to be discontinued and allotted only to ex-servicemen. The response number 1 thereafter issued a communication dated 25/3/2022 asking the petitioner to vacate the retail site outlet with an option to relocate its petrol pump at the end of the premises. Thereafter, there were certain developments in as much as the state of Meghalaya, who had been impleaded in an earlier petition, namely WPC 193/2022, informed that the said piece of land, a plot of land, was also required for expansion of the highway, and that the petitioner could be offered an alternate piece of land. Pursuant to these developments, a plot of land was identified and allotted to the petitioner, for which a lease agreement was then executed. So, The petitioner thereafter had approached the respondents for setting up of retail outlet, but also ever informed that in order to shift their current retail outlet, they were required to sublease the plot of land over to the respondent number 1. Next paragraph. The petitioner being aggrieved with this direction, more so as the terms of the lease did not permit subleasing of the land to the respondent 1. Is therefore before this court, or is seeking directions, appropriate directions from this court to where's your to allow them to set up a fresh IOCL retail outlet in said premises, feeling which to allow the petitioner to set up a retail outlet of any other oil company. So, what do you have to say, Mr. Khan?
Lordship, Lordship, can you just rely on para 3 of my affidavit?
Yes.
Our specific stand is at para 3, Lordship.
Yes. MSM Hazarika, and a senior counsel with so and so, if I have submitted that the situation being situated thus, the petitioner is left with no alternative but to terminate the relationship with IOCL for the new retail outlet. Can we record that?
Lordship?
Can we record that you submit that because of the situation that you are compelled to terminate the relationship, the existing relationship between IOCL for this retail outlet, or no? We will record that.
That's not necessary, Lordship.
Okay.
But that she was praying for the liberty that she may be allowed
liberty,
to
yes. So once
to
we
enter.
get, we automatically be terminated.
And okay, the next parameter, Mr. K. Khan, let us hear counsel also.
We are relying on para 3, Lordship. Lordship can just quote that para 3. Para 3 we have given the why we could not go ahead.
Appearing for the
respondent 1.
Respondent 1 and 2 has in his reply has drawn attention to this court to para 3 of the affidavit file. Hence, submitted that the respondent corporation primarily allots dealerships in 2 categories, that is A side and B side, and that the retail outlet of the petitioner is an A side, and with regard to an A side, the control of the said outlet the control of the land on the said outlet is with the corporation stroke respondent, as the land is either purchased by the corporation or taken on long-term lease by the corporation from the landowner. Besides, apart from this, the council submits that the entire investment for development retail outlet is made by the corporation. And since all investments being made by the corporation, it is imperative that it secure its investment by retaining control of the land, physical land, yes. With control of the land. He thus submits that, he then submits that the respondent number 1 being bound by these directives, the subleasing of the newly allotted land of the petitioner to the IOCL, to the respondent, was necessary to start the process of allotting the new retail outlet. Yes. Next paragraph. MS Hazarika, Leonard Senior Counsel then submitted that as the subleasing is not possible, the petitioner may be given the liberty to approach other oil companies for establishing a new retail outlet in the said allotted piece of land, which would not require the subleasing of the same to the new entity. So, next paragraph. This court has heard the considered submissions made by the legal counsel to the parties, also examined the materials on record. So, it appears that the stalemate has occurred due to the directives under which the respondent was bound. So, as the situation has changed, and as the retail outlet sought to be established is on a newly allotted piece of land, which has been given on lease by the state government, comma, in the considered view of this court, the petitioner will be at liberty to seek other avenues to establish the same. Yes.
In terms of the lease,
In terms of the leases, as given, with the in view of the fact of the case, matter accordingly stands disposed of. And the second one?
Second one, Lordship, which may be heard and order passed.
Where is that?
Because ours was cancelled, and thereafter they recalled it. So we may be
Where
heard.
is the in order? This is for another outlet or the same outlet?
And a tender was called.
Called, Lordship.
So they could not qualify and they filed an objection.
And Lordship, that is at Annexure 11, page 50. Page 50. Annexure 11, page 50. The email, it's an email, Lordship, actually.
Annexure 11.
Annexure 11, page 50. 50.
The petitioner. Who are you, Yara? You are the petitioners.
And we are the petitioners.
1, 2, 3, 4, 5, 6.
Yeah, we are all the petitioners.
You are a HUF or something? Or
HUF?
no?
Not really. We are just brothers.
Oh, yes.
It's getting together in a
6
partnership.
petitioners.
A family partnership.
Who are stated to be
3 of the sons
partners
apply.
of a partnership. Yeah, the 6 petitioners.
6 petitioners.
Yes.
1, 2, 3
who are
applied.
stated to be the
3 applied.
partners of a partnership firm under the name and style of MS Ashok Auto Service. Now before this court, being aggrieved with a decision conveyed by an email dated
19 July
2024, whereby the I can't read it also so small.
Regret that your candidature has not been found eligible.
They have the said firm has been found ineligible. Where is it?
In the email, Lordship.
It's so small, the print.
Yes, dear sir, please refer to
Is there
application. We regret to inform you that your candidature has not been found eligible for the RO leadership on the basis of document.
Auto service. No, wherever is said firm has been found to be has been found to be eligible for retail outlet dealership on the basis of documents submitted by them. So, the next paragraph, MSM Historical and Senior Council has submitted that. What is submissions?
The Lordship, we were given no hearing.
That their application was not
sought to be
considered,
rejected without giving us a hearing.
was not considered and was cancelled or rejected without affording the petitioner an opportunity of hearing. Where have you said that? Did you appear before the...
No, we were not appeared. We were just given this letter. After decision was taken, we were asked to file a representation.
No, Lordship,
and we filed a representation.
On the next page, Lordship. Annexure 12. Annexure 12, page 51. So against this rejection, Your Lordship, they have filed a representation.
We filed a representation.
29 July.
Right.
So they are asking for hearing on this representation now.
Because they had cancelled it the day we filed
page?
it.
That's page 51.
51.
The next page.
51.
Right.
We filed a representation.
Against rejection, they file a representation.
Yes, MSM Hazarka submits that against the said rejection, representation dated 29/7/2024 have been referred before the respond number 1. Respond number? Just give a correct respond number.
Shishir Kumar, head office.
The head of division, number 2. For the respond number 2.
Respond 2.
Number 2.
Which, however, he does not heard yet all till now.
No, they had cancelled us in between. After the interim was passed, we said not to pass an interim order, cancellation order before hearing us.
We had disposed
on the same day, on 29 July itself, they passed a cancellation order without hearing
Well,
us.
we have to record that also.
No,
Yes, yes.
And
Mr.
then they
Mazarika
withdrew.
submitted that the cancellation was in the teeth of the orders passed by this court.
Yes,
Dated
yes.
29th
dated 29.
July 2000,
Where, which page is it?
2024.
Have you annexed it?
Yes.
Yes.
In an additional effort, they have filed, Your Lordship. They have annexed that.
We filed an additional affidavit.
Ahmedabad submits that the cancellation was done
On 29th, after the High
in the
Court order.
teeth of the orders passed by this court, wherein where the order? Where's the order?
High Court order dated 9/8. Lordship will find in my additional affidavit. Dealing Commission, this Honorable High Court, by order dated 9/8/2024.
This is after file on 16/8/24.
Lordship?
The order,
High Court order was.
High Court order was passed on them.
And
we had given the representation on
29/7.
And
29/7 they cancelled it.
Lordship, we come to the additional affidavit, the facts will be clear, Lordship. Additional affidavit filed by them.
Yes, we filed. No, the additional additional.
Lordship will come to
This
para
one.
2 and para 4. Facts will be clear.
Yes.
Para 2 says, Your Lordship, the interim order was given on 9th. So there was a mail sent by us on 10 cancelling it.
It submits that.
Yes.
No, I'm Pomshagato. Even Mazarika submits that. This is 279, correct?
279, yes, Lordship.
279.
Yes, Lordship.
279.
When the instant writ petition was filed on 7/8/2024 before this court, challenging the said email dated 19/7/2024 and moved on 9/8/2024.
Yes, Lord.
this court was pleased to grant time till 19/8/2024
Yes.
to the learned counsel for the respondents to obtain instructions, and directed that till the next date, the cancellation dated 19/7/2024 was not to be given effective. Stop. She then submits that, however, in total disregard to the orders passed by this court,
an email was
the
sent.
authorities issued an email dated 10/8/2024 to the petitioners, and forwarded letter dated 29/8/2024.
Yes, Lordship, that's exactly what happened.
Yes.
That letter was actually that order was decided on 10th day forward, and they wrote it 29/8 because we signed our representation. Exactly what has happened. It's 29/7.
Certain communications were exchanged between the respondents upholding the early order dated 19/7/2024.
Lordship, kindly come to our reply at para 7. Lordship, will just get the facts very clear.
2024.
My reply to their petition, so the facts will be very clear, Lordship. Lordship can...
They have withdrawn it subsequently.
We withdrawn it, so all the details are given in para 7.
They have withdrawn it, which was subsequently withdrawn.
Next, however, she submits that, as it appears that there was an error, and she submits that the respondents, perhaps on realizing the error, had then subsequently withdrawn the
impugned letter.
Impugned letters.
10/8/2024 on 19/8/2024.
On 19/8/2024.
10/8, which paragraph is that? 7?
Say para 7, Lordship.
Para 7 of the affidavit in opposition.
Yes. Don't letter. Letter 29/7/24.
Yes.
The communication dated had withdrawn communication dated 29/7/24 by letter dated 19/8/2024.
Lordship, yes.
Next paragraph. At this stage, the senior counsel only praised that the representation as preferred be disposed of by the respondents in accordance with law. Next, by Mr. K. Khan, the senior counsel appearing for the respondents also does not dispute the submissions made by the counsel for the petitioners, and submits that the answering respondent, due to bona fide mistake, had issued the letter dated 29/7/2024, and the same was however rectified. In this view, he further submits that the representation as preferred by the petitioner will be disposed of
after hearing.
Yes, according in the context after hearing the petitioner. Stop. Next paragraph. In view this, upon hearing the counsel for the parties, as the limited question is on with regard to the non-hearing of the petitioners, it is directed that the respondents shall take up the representation dated
29/7/2024, Lordship.
Yes,
Annexure A12, page 51.
for consideration after affording adequate opportunity to the petitioners.
Obliged.
The same.
Obliged.
Matter stands as further. Yes.
Time frame, Lordship, within a month?
Yes.
Anytime.
Anytime.
Within a month.
It is expected the matter to be disposed of expeditiously as possible.
Obliged, Lordship.
Item number 7.
Where's Ailingwa?
Number 7.
Instructions. Yes, what's the matter about?
This is with regards to approval of the school managing committee, Your Lordship.
Yes. What instructions you received, Mr. Are your opinions matter?
Lord,
Whose opinions matter?
the counsel is I lingua, my lord.
Then call her.
Probably she's on.
Have you received instructions?
Yes, Your Lordship, we've
Then?
just received, Your Lordship. I'm praying for
What does
some
it
time,
say?
Your Lordship.
Let us see. What instructions have you received? You haven't filed affidavit as yet. Oh, you have managed, it is invalid your meeting as per instructions.
Can I?
No, you can't see it, I have filed affidavit. Just wanted to see that. Yes, MS Alingwa submits that instruction that when received. Please you allowed to file affidavit within 2 weeks, yes. Today is allowed.
Item number 8.
Obliged, Your Lordship.
Not in this case, but though the affidavit is ready, we received some
Does
additional.
the standard, does your standard mind?
No, my lord.
The affidavit is ready.
No, my lord. It is
You
ready.
ran out from the pen to sign it.
No, my lord. We received some additional instructions. So, my lord, if I am allowed to file by Tuesday, my lord, Monday or Tuesday.
Yes, as prayed for the 1 week's time allowed. Affidavit, yes.
Obliged.
9.
Please, Lordship, we are yet to receive instructions in this matter. I'm praying for another 2 weeks, my lord.
Your Lordship, I'm appearing for respondent number 11. I pray for 2 weeks' time, Your Lordship, to come back.
Give them time or don't give them time?
We'll give them time, Your Lordship.
Give them time, okay. For the 2 weeks, as prayed allowed for affidavit, yes.
10.
Chief, I'm awaiting the instruction, Lordship, here.
Yes, for the 2 weeks allowed for affidavit, as prayed.
Obliged.
Hearing. Item number 12.
Yes. Yes, Mr. Jha.
My lord. My lord, this is the case of grant of disability pension, my lord. We are claiming for the disability or invalid pension, my lord.
When did he was discharged as invalid, as disabled?
1978, my lord.
Well, serious decisions. You can't rely on Himachal decision anymore.
My lord.
You can't rely on Himachal decision.
My lord, it's 1954 that was, my lord.
You're relying on Himachal decision.
Uttarakhand, my lord.
There's not a decision of Supreme Court.
That has not gone to Supreme Court, my lord.
No, that's not a decision.
Supreme Court.
There's one case of Mr. Pandey that is able. Which case was that?
Lots of dispose, but that order is not with me today.
Where's the order? You've seen the order?
Which? No, my lord.
What is the name of that case? I forgot also.
I'll place it, my lord. Today I didn't bring it. I'll give him a copy.
You're not aware of it?
My lord has passed it.
Yes, from this bench itself, disabled.
I will look into that one.
It might help you, it might go against you. We don't know.
My lord.
This matter after 1 week to enable petitioner to obtain the just yes after 1 week, yes. Just get it.
My lord.
I forgot about that also.
18.
Please, Your Lordship. This is the matter relating to the cancellation of the petitioner's nomination from the MDS seat which was reserved for the state of Meghalaya in the Regional Dental College in Guwahati. Petitioner was nominated against the state quota for the Masters of Dental Surgery, and her nomination was cancelled on account of the fact the private respondent had a higher need score.
Okay.
That's
Higher
the issue.
need score means like at a time consideration, they were considered also, but it's given to you.
Lordship. No, they were not in the running at that time. They had not even applied
not running
as of
at
the
that
time.
time.
Lordship.
This is not a case of arbitrary selecting you.
No. That's not the case, Lord.
Okay.
I'll just take your Lordships to the relevant documents. So the petitioner's NEET result is at page 18. Lordships, at page 18, kindly see in the box serial number Roman 9. That's her result, her score 412.
Okay. Neat result. Score 412.
412. So then, in the first week of April, she visited the office of the DHS to inquire whether there was any seat which has been intimated by any college outside the state. She was informed that at that point there was no intimation. Subsequently, in the last week when she visited, she was informed that there was some information about a seat from the Regional Dental College. Lordship, this is the intimation, 8th April 2024 at page 19.
Okay.
So this is issued by the principal of the Regional Dental College. It's issued to 3 states. Kindly see, Director of Medical Education, Government of Tripura, Government of Arunachal Pradesh, and at serial number 3 is the Director of Health Services MI, Government of Meghalaya, Shillong. It reads, subject nomination of candidates for MDS course in Regional Dental College, Guwahati for the year 2024. With reference to the subject cited above, I have the honour to inform you that as per the existing procedure of allotment of MDS PG seats, the state of Tripura, Arunachal Pradesh and Meghalaya have been allotted 1 seat each against their specialities for the year 24. At serial number 3, Lordships, while Meghalaya was allotted this seat, prosthodontics and crown and bridge. You are requested to nominate 1 candidate keeping in view of the following criteria and send the nomination on or before the time schedule of MDS admission to complete the admission process to be made by the Government of India. I therefore request you to kindly nominate 1 candidate who qualified in the NEET MDS 2024 and domicile of the state. 1. Candidates should be domicile of the concerned state. Candidates should have qualified in the NEET MDS 24. If the first candidate refuses to join the course for any reason, she should surrender the seat in writing. In that case, the seat will go to the next waiting list candidate of that state. Leaving the course in between by nominee is a great loss to the institution and respective government. Now, following this, on the next page at page 20, Lordship will find my application dated 7th May 24. This is as early as when I filed the application. Then at page, my lord,
4th May.
7th May, my lord.
Oh, 7th May, sorry.
So I enclosed all my credentials and filed this application to the Director of Health Services.
Okay.
It's pursuant to this, the DHS drew up this merit list dated 22/5/24. Now kindly see, this was issued by the DHS and it was addressed to the Joint Secretary of the Government of Meghalaya Health and Family Department. Request for admission for MDS course. In enclosing herewith copy of the letter dated so-and-so 8/4/24 received from the Principal of the Regional Dental College, Guwahati, I am forwarding herewith list of applications of the following BDS graduate, bonded students and non-bonded students along with enclosures for nomination for postgraduate study in MDS course for the following academic session 24-25. In the first column, there are 6 candidates under the bonded students category, and the next column, non-bonded, is the petitioner with her score at 412. So in this list, Lordship will find that she has the highest score.
It's given by respondents only.
Lordship, this is their internal communication. This is like a merit list that they've drawn up. Now, as on 22/5/24,
that means she's, yes, okay. Select, this is what we call,
this is a nomination list, a list of a merit list, if I may say that.
Yes.
So, Lordships will note, as on 22nd of May 24, the private respondent or any other respondents did not, any other persons did not feature in this particular list. So, on the basis of this recommendation, your Lordships will find at page 22 is an order dated 11th July 24, issued by the Joint Secretary. And it reads, the Governor of Meghalaya is pleased to, there's a word missing, it should be nominate Shri Shireen L. Dakhar for MDS PG course against the seat allotted to the state at the Regional Dental College for the academic session 24-25.
Okay.
But pursuant to this nomination, I secured my admission and paid whatever dues were there. That's at page 23 on 22nd of July 24.
Okay, fine. Now what happened?
So thereafter, we also secured an accommodation. I participated in a national conference and so on. And then kindly come to page 31. 31.
Yes. Yes.
So I received a rude shock from my principal of my college. This is the order cancelling my nomination. It reads, this is on the 19th of August 24. In continuation of this department's letter number so-and-so dated 11/7/24, the Governor of Meghalaya regrets to inform you that your nomination for MDS PG course against the seat allotted to the state at the Regional Dental College for the academic session 24-25 is hereby cancelled, as there is another candidate with the highest need score as per the second list submitted by DHS on 29/7/24. Now, the three very important things as far as this letter is concerned. Number one, my lord, this order was never served upon me formally by the state. And I have made a categorical clarification in my rejoinder as well. There was a complete violation of the principles of natural justice. And lastly, what is important,
Yes.
well, is that in this letter,
Yes.
they have referred to the second list and they claim that it was submitted on 29/7/24.
Yes.
This date is very crucial. So kindly just take note of the date that they've mentioned, my lord. So on the 19th of August, they issue an order cancelling my nomination, and on the next page, my lord will find at page 32, is again an order dated 19th August, nominating the private respondent number 5. This is the Governor of Meghalaya is pleased to nominate so-and-so for the MDS PG course against the seat allotted to the state at the Regional Dental College for the academic session 24-25. Now, admittedly, his need score is higher than mine. Mine was 412, his is 434. So, having been made aware of this, my lord, I immediately rushed to Shillong
Yes.
and wrote a letter dated 28th August, which is at page 33. I'll just read this out. I am extremely distressed and disturbed to receive your letter under reference cancelling my nomination for the MDS PG course against the seat allotted to the state of Meghalaya at the Regional Dental College for the academic year 24-25 on the ground that there is another candidate with highest need score as per the second list submitted by the DHS on 29/7/24. As you are aware, I have already been admitted to the course and have joined my classes. Further, all applications for MDS seats for 24 intake have been closed. Given that my admission was duly completed in accordance with the relevant instructions, I respectfully request you to provide the following. 1. Copy of the second list with the list of candidates.
Yes.
2. Copy of the application for allotment of the PG seat under the state quota filed by Dr. Alvin Douglas, Kharmalong. This is the respondent number 5. Now, this was necessary because I actually wanted to see where the second list was. And number 2, when did the private respondent actually apply? Till today, my lords, they have not responded to this letter. So this is a letter I had written to the Joint Secretary, and at the next page, a similar request was made to the DHS.
Where's the second list copy 29?
I'm just coming to that, my lords. They've filed it along with their affidavit. I'll come to that. Now, my lords, I thereafter approached this honourable court on the 29th/8/24 by way of an unlisted motion. Lordships may recall the Learned Advocate General appeared on that date, and they had opposed this petition on the ground number 1, that this process was questionable because this vacancy was never advertised, number 1. And more importantly, they had also mentioned while opposing the prayer for the interim relief, it was argued that the private respondent number 5 was in fact, had already secured his admission in the Regional Dental College. Now, we later learned that on the day when the motion was being moved, the private respondent actually obtained his admission in the college. So this happened on the 29th of August, on the very same day. What is interesting is that the department had real-time information about what the private respondent was doing. They have taken a keen interest in the activities of the private respondent.
Who is the private respondent?
He's the one who's been I've been dislodged and he has been nominated. He's also applying for the same seat, my lord. Now kindly have the affidavit filed by the state. This was filed on the 24th of September 24 by the respondent number 3.
Respondent number
3. So this is filed by the Joint Secretary.
Yes.
And it's kindly have page 3.
Yes.
I'll just read from Roman 3 onwards.
Yes.
It is submitted that accordingly the respondent state by letter dated 22/5/24 addressed to the Joint Secretary Health and Family Welfare Department Meghalaya forwarded the list of 7 candidates, bonded and non-bonded, whose applications were received for pursuing MDS course for academic sessions 24-25. It is submitted that amongst the 7 candidates, the petitioner had secured the highest marks, 412, in NEET MDS 24. It is submitted that based on the aforesaid list, the respondent herein, by letter dated 11/7/24, nominated the petitioner for MDS PG course against the seat allotted to the state at the Regional Dental College, Guwahati, for the academic session 24-25. Now, this paragraph is relevant. However, it is pertinent to note that prior to the letter dated 11/7/24, the second list dated 2/7/24 containing names of 2 more candidates, namely Dr. Alvin Douglas Kharmaulong, respondent number 5, and Dr. Sunny Prasad, who scored 434 and 427 marks in the NEET MDS 24 respectively, was received by the office assistant of the answering respondent. Now, this is the Joint Secretary on 5/7/24, but could not be processed as the second list dated 2/7/24 due to unforeseen activities involving the concerned office assistant dealing with the matter, whereby her mother was admitted to the hospital, necessitating her to... My lord?
Where's the hospital?
No mention has been made.
No, how can you say where my mother is in the hospital? Who's the...
Some office assistant. No, what it says, it could not be processed.
The mother of the Joint Secretary?
No. Concerned office assistant. Undisclosed, unnamed office assistant. So the entire blame is now put on some office assistant whose details are not...
So you're going to suspend her now?
That's up to the state.
For her latches?
So I'll just read this out. Concerned office assistant dealing with the matter whereby her mother was admitted to the hospital. Now kindly see the date. Necessitating her to take leave from 24/4/24 to 29/6/24. So April to June. But whatever else has happened here is from July onwards. And upon her rejoining, she continued to attend her mother's care, resulting in her inability to attend the office on several dates. During her absence, the matter remained unattended by other assistants in the department. Kindly see what a convenient explanation.
No,
now this
convenient. It just...
It's made up.
I don't want to use some other words. That's all.
It doesn't end here, my lord. It doesn't end here. Kindly take note of this date. They've mentioned that the...
No, I mean, you cannot do this. I mean,
Lordship, Lordship.
You in office, you can't say, you just... Who's, I thought it's the Joint Secretary. The Joint Secretary is mother.
No. It's the office assistant.
Let him appear in person. Yes.
But just one more thing.
With the records. No, let him appear with records.
Lordship.
And all the leave applications, all office assistants that were there, if it corresponds to what has happened. This is totally uncalled for. This how can affidavit be filed? I cannot understand. This submissions here in this para 5. Anyway, yes.
Well, just one more thing. In para 5, kindly see, just towards the earlier part, it says that the second list dated 2/7/24. The second list of these 2 additional candidates.
See, what is apparent on the face of the record to any person who has some basic intelligence is that they're trying to cover up,
Absolutely.
That was never there.
Absolutely.
How to cover up, to bring that person into contention. They might have had a high need score, found that could not get anywhere else, comes in the middle and maybe having some influence. That's what's being done.
Well, I'm just pointing out something.
It smacks, this is if you talk about malafide.
Absolutely.
You talk about malafide, I mean, You talk malified, I mean, this is a classic case.
I'm very obliged, my lord. I'm just pointing out something very glaring here now. So what they've said is that second list was submitted to his office.
His mother is ill,
absolutely,
took leave in June, and then couldn't put up the file. No one attended her duties. I mean, you're running a government, or you're running,
absolutely,
a mom and dad store.
And something even more glaring, my lord. Just notice this. They are saying that this second list was submitted to his office on 5/7/24. This is the date that they have assigned here. Kindly go back to my writ petition. I'll point out something very glaring.
Leave that aside, I mean, your case, but then the way, yes.
Page 31. Just for a moment at page 31.
Yes.
At page 31 is the order whereby my nomination was cancelled. And they have sent the last line, as there is another candidate with the highest need score as per the second list submitted by DHS on 29/7/24. But here in this affidavit, they contradict it and they say they received on 5/7/24.
The assistant DHS, am I?
This affidavit is sworn in by the Joint Secretary. They're just trying to bring him in contention, as your Lordship has rightly observed.
I'm afraid this is, I'm afraid it speaks very ill of the affairs of the department.
As Lordships have rightly observed, they're just trying to bring him in contention.
You print the records, all the records. But at some length from after hearing the inner counsel petitioner and closing the government Sarabin affidavit, this court deems it necessary to call for entire records regarding the admission process that was adopted, including relief applications and medical certificates of any of the said assistant who is said to be absent but who remains unnamed affidavit.
Does the interim order may kindly be extended in the
meantime?
meantime?
Interim order will be extended, of course.
Lordship.
Interim order extended further orders, yes.
Lordship. Highly obliged.
Lordship, we filed the affidavit, my lord, and we have admitted on the
admission. If the very fact that can be sent at that para 5, some assistant whose mother is ill, you have to lament. You can't say anything.
No, Lordship, what I'm...
you have two people, okay, fine. Here, what is it's all the fault of the department what they've done. Anyway, we'll see. We will take this matter logical conclusion. If
my
it
lord,
involves other things also.
What I want to submit is that maybe certain lapses have been there, and we have placed it on affidavit, my lord.
If the lapses are there, don't place it, then don't write such an affidavit.
But Lordship, our prayer before this honourable court is that if the matter can be decided at this.
Yes.